This is a Niche Radio podcast. Subscribe to this podcast on iTunes or log into www.nicheradio.co.za.
Welcome back to SuperDads. I believe this is going to probably be the final recording of this series. This episode recording is going to focus more on the practical aspects. So, putting the legal documents together, what Clive actually went through on terms of approaching the court, who spoke to, what assistance he got, who consulted, the costs involved, as well as the current strategies going forward with additional legal documents he's going to be filing. So, Clive, welcome back. I don't want you to be too strained. I thank you for pushing yourself through this. I know it's not easy, particularly since you're very kind beforehand, putting everything together to send it to me. So let's push through for this last stint.
Okay.
So let's cover sort of putting the legal documentation together. Number one, persons out there, should they themselves approach the court? Yes and no. I know it's yes under certain circumstances and no under others. So what's your advice or criteria around that?
Without my legal experience, never, I'm able to get up to speed very quickly on the technical stuff. So I can download the acts, I can download the practice directions, the rules. I can look at a lot of court cases. I can figure all out. I can figure the theory out, but the practice, you have different choices. So do you do an urgent? Do you not do an urgent? Do you do a part A, part B? Who do you decide are the parties? When do you file, the filing times and so on? If somebody doesn't have either a lawyer or someone like me to guide them through, I would not recommend going by yourself. It's like a baby walking into a lion's den.
So the two aspects that you mentioned just now about having an attorney or having you guide them through the process. So the one thing with an attorney, again, this is the first part of the argument here, which the judge already pretty much ruled on, but it's not definitive yet, is the PAJA or the administrative law, civil law side of it. And that pretty much, it's much easier to find an attorney that has the skill set on PAJA. Where in terms of the health argument, that's a lot more tricky and specialized, and you end up having headaches and having a lot of money wasted trying to educate an attorney on these different facets. That's my interpretation and opinion and experience. But I think from a administrative law side, it's probably very much more worthwhile for a person to seek an attorney with the skills and say, listen, this is the evidence, help me draft the documents in order for this to comply with administrative law. Is that your concurrence?
No. Well, yes and no. You have to find an attorney who, most of them haven't been through a PAJA. So it's like 99% haven't been through a PAJA. So you're going to GPs when in fact what you need is a gynecologist. You follow what I'm saying? Yes. It's if they haven't done it in the past, it takes a while to get up to speed. It would be very, and then of course they have to find an advocate to go to court, and again, very difficult to find someone who knows the problems with dealing with the city and dealing with large corporations, and very expensive. So the telecom, which is the key player in our case, your big telcos, your big corporations, when they're faced with this, basically what they try to do is they will ambush you. There's a lot of ways in which they can ambush a lay litigant by filing late, by presenting in limine applications, by using technical terms, and by pushing up your costs, the person's costs dramatically. So a person would end up with very high costs and would abandon the litigation in the first few months. Or if they went the long route, it would be 6 to 8 or so months. If you got the right set of attorney advocate who are passionate about it, who've done a bit of it, who know they don't have to come too much up to speed, and it's a pretty straightforward a case of a false tower just being put in, you'd be able to go it.
And you didn't use an advocate. You had an attorney by your side in the second one, because I believe in your previous application, which you contesting or appealing in constitutional court, you were purely by yourself. You didn't have an attorney with you.
No. What happened was when we saw the tower go up and we realized that there was something faulty with we didn't have it all, but within a week or so, I said, there's no way I'm going to come up to speed in a week or two. We need an urgent application to stop the tower going in, to stop the construction. Luckily, I had an attorney that I trusted, an honest attorney, and I went to him and said, look, we need to do an urgent application to stop this. He said, yes, fine. He got an advocate, and we went to see the advocate. The advocate hummed and hawed and, vacillated and so on, this and that and so on and so on. I wasn't that happy with his response, but he said it's urgent. And then what the advocate did was delay the matter for 2 weeks by insisting on the wording of the letter and the drafting and everything else. So 10 days had gone by, and I said, look, this is urgent. We are now, the judge is going to say, but you've waited, why have you waited 3 weeks? It's not urgent anymore. Till the company is working overtime. They worked Saturday, Sunday, they worked from 7 to 7. They worked under car lights. They did everything they could to speed up that tower. So we went back to the advocate, and I said, look, you've put us between you've put me between a rock and a hard place. You've delayed this, and I don't know why. And they're going to get us on saying it's no longer urgent because you should have brought this within a week or so. The advocate hummed and hawed and said, look, I'm going to have to withdraw. I've got another case that I'm not able to handle your case. And it was a shocker. He said, I looked at him and he said, I won't charge you. Well, you don't do that sort of thing. So there is a case where I had the right lawyer who admitted that he would need the right advocate, and the advocate then strung us out and dropped us, and I then had this was now 3 weeks, I think 2.5 weeks had gone by, or 2 or 3 weeks. And I just said, well, I now have to get up to speed extremely rapidly. And I knew that the urgent would have to stop them from mounting the tower. They were getting the base ready. And I went in with an urgent, and I did this myself. But by this time I'd gotten up to speed on the law. I'd gotten up to speed on the facts and so on, gathered a lot of the facts. And so when I went in, it was good. I did a part A, part B, which the advocate have said, no, I shouldn't do. And I really didn't agree with that. And I just got a bad judge, and I had an advocate who just said to the judge, "This guy doesn't know the law. He can't even file. He's filed. He's served 2 applications, and they're both very different." So the judge spent a long time giving me a lecture on why I should be using an attorney, because I didn't know what I was doing. And I was shocked by this totally, because I said, look, there wasn't any problem. And afterwards, I said, I want to see where the differences were, because I checked them thoroughly. And I saw an internal memo when it came to costs, and they said, oh, just ignore the guy. So we got a judge. It got bounced to a judge who I suspect either way, I got the impression, okay, and now this is where I have to be careful. Either way, I got the impression that the advocate just strung it out and dropped us. I got the impression that the judge couldn't care, and he's got a big corporate and he's not going to stop them. And he just said, it's not urgent. You had plenty of time to file this. Didn't want to listen to the problems of the advocate. And he said there's no health or health reasons or hazard reasons, despite the fact that I said we're elderly, I've got medical conditions. Wasn't interested in that. And he also said that you hadn't joined other parties. Now this is an urgent application. So all he had to do was say, I'll give you an order for 2 weeks.
Yes.
And the other parties then have to show cause, which is what happened this time.
Correct.
It was virtually the same application, except I had a huge amount more detail. And of course, I had the time. I knew I had 180 days with Padger. I knew the time limits. I was within the time limits. So there weren't problems with condemnation and so on. Yeah, very tricky. Oh, and then, sorry, before I went on this last one, I went back to my attorney that I trust, and he is honest. And I said, look, because I've been involved in another area with a problem tower, they have the name of a good advocate. And I would like you to contact her and make an appointment to see her. So on the Friday before the Tuesday, in other words, Friday, 8 days ago, I saw the advocate with the attorney. We spoke and chatted, and I said, I'd like you to be there to observe, because it's too late to argue the matter. The papers are all in. And I said to the attorney, she said she couldn't make it. I said to the attorney, please, I'd like you to be there just in case to observe. And if something happens, you are there to give me, if they ambush me, you are there to give me legal advice. That was expensive. That was a 12,000 Rand exercise for the appointment and for the attorney to observe. But it was worth it, because the attorney said, just extend this period, and he explained a couple of things when we were drafting the judgment. If I didn't know the law very thoroughly and know how they ambushed me, they would have put in an order that they could have wiped me next week.
And it's very tricky because, as you said, it's also about a formality, a ritual. There's a certain protocol and a formal dance to being caught. And with the previous judge, yes, the law encourages that in the Constitution. That's, hence why you can do your appeal. Any citizen can approach the court themselves.
Yes.
And even the circumstance, again, the whole thing of urgent interdict, you have to demonstrate the qualification of life or death threatening or other, or the extreme, prejudice against your constitutional rights, which you were able to present. But because he was more of a stickler, like we see with the formal training or allopathic doctors, if you don't have a certain suit on or a certain grace and a certain way of mannerism, I'm going to show prejudice towards you. And no matter what you say in narrative, it's going to be very difficult or working against you. And that sort of was also one of the backbones in my thesis, was to present a document that can create a structure that, or model that, when it is against like sort of a municipality or a citizen like yourself against a cell phone tower, you're using more scientific facts and data to remove a judge being subjectively biased. Or if he does do it, you have more grounds to appeal. But again, it's another complicated exercise. It takes time and it's difficult. So in your case here, you entrusted a reliable and ethical attorney to provide that sort of respect of the court, to show that, you know, that this man is followed due procedure, and please hear him out.
The attorney was sitting at the back. The judge had no idea that I had an attorney with me.
Okay.
He only came into play when they presented me with the draft order and we were negotiating. I said, no, I'm not accepting this. No, they take this out. And they said, no order as to costs. I said, no, costs will be to reserve because I am going to fight costs. I want to be paid as if I was an advocate and an attorney.
Yes. I think also a key thing here is that you, like I said, you had a background in legal experience and consulting with attorneys and advocates, and you knew exactly which trigger words to use. And
yes.
That's what they look at these documents. If, like you said, this time round, you focus more on PUDGA. So if you don't use a specific act, or you don't put the order, like you said now, for the tower to be turned off, then
yes.
the judge would, even if he felt that, you know, he empathizes with your situation, he wants to say you should do this, he's not allowed to do that.
Yes.
And that's what makes it very difficult and tricky. So that's what I love about, again, the precedent of your case and having it for the show notes for our listeners, is that it puts that precedent that you actually went out to very specifically, like you said, at the end, the attorney helped you out. You want this excluded, you want this included. No, this must be done correctly because there's very specific wording that can change the whole narrative of this entire story. There was you probably reviewed it, a municipality, City of Cape Town versus Telkom, where the whole thing was bylaw, where a cell tower didn't follow the bylaw properly, and therefore the permit's rejected. But what has happened in that is that the city purposely didn't include a decommission order on the tower.
Yes, So
because
you're quite right with regard to that, is that if you don't have the tower turned off right away, they keep using it and drag it on for years.
Yes. But what was done is, because I was looking at the drafting of the document and what was being shown as the big start of the narrative, it was bringing about that there was meant to be a decommission order. But because it wasn't done in the end for it to be turned off and or decommissioned, it was never done. So all it required was for Telkom just resubmit a permit application and the tower can remain.
Yeah.
Even though they're following the same process as you experience now of not following all the tick boxes. So that becomes another citizen or attorney or advocate to band together to retake up that matter or similar matters to that.
But there are people like myself who have got the time, who have got the inclination, who are prepared to research the subject and present it. And if the rules and regulations and laws were clarified sufficiently for self-represented litigants, and judges were told, instead of being highly technical, you have to look at what is fair and just, and although you have to follow the law, you are entitled to stop ambush attacks.
And you mentioned also earlier that a person can consult an attorney, and as you mentioned, maybe 1% out of the attorneys, they will actually have experience in PUDGA and can properly argue it and present it. Yes. You also mentioned that persons can consult you for advice as well. Now, I think from my opinion, my personal experience, it does sound like a very open invitation. And what happens with that wording of they can consult you is that they will want to consult you like you're an attorney or advocate and want to do the battle for them. I think we need to be very specific on what you mean by consult, in terms of you know, they put certain documents together, or you say you can approach this person or get this document in check, or learn this kind of language. Is that what you mean in terms of that? Because again, you know, you learn all these words, and it can be quite a brain explosion for a person to try to play catch up. So elaborate more on how a person can consult you.
Thank you, because I actually have a long-running battle in the Pretoria High Court, which has been going on for 4 years, and which has given me a huge amount of experience, because I am on Monday filing in the Constitutional Court against a decision there, and I'm filing in the Supreme Court of Appeal. And I've also got a number of commitments of my own that I have to do, but I'm willing to help people on the basis of pointing them in the right direction, listening to their case and deciding whether they have a case, because if they don't have a case, you can't go anywhere. So I'm willing to say, look, have you, you know, I'm helping another group, and I said, the first thing you must do is, here's the form, fill it out, and it's per year. Go and get the documents and get a copy of all the documents. I can scan it very quickly for you to tell you what is wrong and what's not. Then you have to do a per year. You find yourself a lawyer, you tell him that you want to do a per year, and you do the per year based on the NBR or so on. But I need site, you've got to prepare, and I can say, for example, one thing I learned is in the original to the court, don't use a grayed out copy. Use a sharp color copy. So, yeah, so I'm willing to help people, and it's a two-way street. Obviously, I'm not a lawyer. I can't give I'm not allowed to give legal advice. I certainly can't charge for it. So it's a matter of, I'm doing it as a sort of community service to assist people in the battle, to stop the state just running all over people.
So just to clarify, so you're not charging for an educational consult. However, a person has to show, sorry?
Yeah. I can't charge.
Yeah, well, you can't charge an attorney, but one could charge an educational consult, but that's a separate action.
Yes.
But you want people to, you charging them in terms of them demonstrating, one would call skin in the game, or
yes.
You know, showing that they've actually made an effort in their application, they're sincere.
Yes, yes. I'm prepared to help people in the interim for the purposes of gathering information, for the purposes of a national fight. I'm doing it for justice and ethics. I'm strange that way, but hey, that's I'm seeing where it's going.
Also, you mentioned one of your writings that you're also looking to do an application to the Department of Health. I don't know if you are willing to discuss that a bit more now, or that keep it under wraps for now for a different episode.
Okay. Look, the Department of Health has issued a directive, which is wrong. It's wrong it's factually wrong. It's destructive to the nation. And I feel that if I were to take them on directly and take that directive on, that I would get more traction in terms of municipalities and government being much more circumspect and thorough with regard to approving towers.
Correct. Yeah, I mean, I found a lot of there was a lot of documented evidence in my study regarding that, and there's a lot of authorized recordings, and it's, you know, creates supportive evidence for that. But again, you know, present this evidence on a public domain or like in a study, it means nothing until the only way it's going to change is if it goes through Parliament, which can take many years and gets very diluted, Or
Yes.
again, the conclusion of my study was it's a lot more quick and efficient to go the high court route because
Yes.
like we have in the cannabis case, you can have legislation passed within 2 years.
Yes. You see, the problem with going direct to the Constitutional Court is that the Constitutional Court is a court of appeal. They don't do all the examination and everything. They look at the judgment and say what was wrong with it. So it might be a matter of, I think it's going to be a matter of going to the High Court first, getting a lot of publicity. And because I'm not a lawyer, I can avoid these lengthy delays. Because that's another thing that happens. Is one of the reasons I handle a lot of the cases myself. In fact, this long drawn out case was because the attorney was dragging it out and the fees were just mounting, and he was taking steps that I knew were procedurally wrong.
So yeah, I think that's a very key thing is that, and again, that's the whole point of this show being SuperDads. It's about individuals like yourself that's going out of their way to create a protective environment, number one, for themselves, so they can be a community leader and lead by example in order to protect the rest of the society and community around them by putting these protection mechanisms. So that, again, is a key thing here. And I like it how you elaborated and explained very nicely about constitutional court. That's, it's like an appeal review process. Because many of these organizations or individuals say, well, I want to become a freedom fighter for cell towers and I want to go straight to constitutional court and have this whole matter turned around. And again, constitutional court is not going to look at you unless something really, really urgent, but you have to demonstrate that you've gone to the lower courts first, like so a high court, Supreme Court, in order for it to sort of do a proving exercise. Like you said with you, versus that one consultation with you, they need to serve first proof that they've gone through these processes.
Well, you can go direct. There is something called direct access where the government is doing something and there is an urgency. So, for example, that directive of theirs is basically unconstitutional on the face of it because it's permitting harm on a massive scale. And I am looking at whether I can do a direct access. It's not too much of a problem because basically you do the direct access and they rule on it. I think they rule on it reasonably quickly. They'll say, no, you can't go to the High Court first.
Yes, which is, I guess,
it's very tricky. This is where I will get an opinion of an advocate, but I will do more research because you've got to read just about any case that involves direct access, and there's a large number of them. So even if you've got a standard case which has got 100 pages in, and there's one paragraph which says something about direct access, that particular paragraph is key. The other thing where lawyers have a great advantage is that there are online sites which tell you basically how to do things and the precedents that you must use and so on. So I have actually gotten access to those online sites. I am an alumni of WITS, so I can get access to their law library. And I've bought a number of the books that the university uses in their courses. And I've bought, there's a volume called Erasmus, which lays out the court rules, lays out the precedent behind them, and lays out the logic, which interprets each phrase and each word very carefully. And without that, you have to have that.
Yeah. And I think that's what's also very useful about this recent order you've gotten now, is that it does provide more weighting, particularly like you said, the Judge Kasim said already, you guys didn't follow ball here. Administrative law is issue. A person has brought about health complaints, and they might say, well, let's look at more rulings. Can you show more evidence of it? Which again, then it become a thing of you have to submit my study to show these are the evidence of it being done on multiple other sites as well. But the judge might say, well, that might be fair, but however, I want to see additional court issues coming with it. So that's we see a knock-on effect coming with that now, because I said, there's matters I'm being involved in at the moment, which are following the same route as you are, showing administrative parts not being done. There is also the secondary co-citing of the health implications. And, you know, when you have a number of those, then it's easier to do direct action, as you said, to go to constitutional court saying, listen here, let's put a freeze on everything, and we need to have a new adjudication on this whole process.
I'm going to have a look at all of this, but certainly I've decided that I am going to be a health warrior when it comes to educating people about cell towers. Look, it's a technology that is here to stay, but people have got to be aware of the dangers. It's like fire, you know. If it's great for cooking meat and for warming yourself, but boy, you can either burn yourself, you can burn the house down, or you can even burn the state down.
No, I think any final advice or words for wrapping up this series that you think we might have missed, or that you process could be useful for our listeners? I know we've covered a lot in detail here, and there's a lot more detail in your documents, which are again in the show notes for our listeners. But yeah, what's sort of your final words as a SuperDad?
I would summarize it by saying the cell phone industry is putting out propaganda and putting out information to make people feel that they know what's going on and it's safe. People need to educate themselves by going to some key sites run by scientists, such as BioInitiative, and the EMRSA site is a good one. And there's Scientists for Wired, and there are other sites that are very good. You've got to be careful of. There are some sites which are there to sell you radiation hoods and blankets and so on and so forth. And they have got Joe Bloggs, who's the electrician down the road, giving you technical advice. And no, they've got to go to experts like you, and they've got to go to the right sites. But they must teach themselves. The bottom line is that cell phone radiation, both the phone and the tower, can be quite harmful, and in fact might even eliminate the human race.
Well, that we're seeing already the epidemiologic effects. Oh, there's my exciting dog here.
Yes.
Yeah. I think those are key things. Wait, give me a second. Let me just quickly attend to it to come inside. Okay, we're back from...
Sorry, do you have shielding in your house?
Yeah, so in my place, we've implemented a number of mitigation shielding options. I've got the shielding on the windows. I've got the Faraday netting on the bed. I've got the shielding on the wall. We've got dispersed emissions voltage transient filters on the wiring. We've got grounding sheets. We've got the lighting modified. So again, what's very key thing is that also with the shielding technology is that when you put shielding, it's very important to have a meter as well to test it. So EMF-SA, for example, I know you do have a lot of contact with Wilma Miles and Dave Miles. They provide a very nice service of renting out meters to help people. Because if you do the shielding incorrectly, you can actually make things a lot worse. You can amplify the amount of radiation in your environment.
I agree.
And then also what people tend to do is that they start implementing other technologies that actually make their health even worse and cause more mitochondrial DNA. So they put LED lights in, for energy efficiency, it makes things worse. So again, all these things have different impacts. Or they might have their kid's bedroom and they'll put the refrigerator on the other side of the wall, not thinking about it, and the child's exposed to very high magnetic fields. Or there'd be things like you talked about your guest being shocked in the shower with the stray voltage. We're using equipment to measure that. Or sometimes if the electrical wiring in your home isn't done correctly, you have field intensities given off by your earth cable or grounding cable, which is not something that should be the case. So you use special equipment to measure and check that. So the whole point of using equipment just helps, because your brain's being affected, like we discussed in episode 2 of the neurochemistry. it's going to use the tools to help give you a better guidance of things and remove this over excitement or concern of things.
Newton was the one who said, when you could put a number to it, you know what you're talking about.
True, that's the one part. And then comes the second thing of actually having a protocol designed for you that you follow, implement to boost your longevity and your health of your body. Because if you're always ill, you're not going to get better. And if you can't modify the environment, you're not going to get better. Interesting, like, again, with my place, I covered on some of the episodes that, like I talked about the jump conduction, the localized hotspot. So with our neighbors, because again, the poor wiring we have in the place that we bought, not going to be here for that much longer, so that's fine. The way the neighbor's Wi-Fi, their router was placed, when it was on the other side of their wall, then the radiation was being blocked by the walls. But when they moved it towards the spot where the plug socket was, the place where the router was pushed, it actually was jump conducting onto electrical wiring, and it was traveling up into our unit through the ceiling and onto the other side. So you'll find these very interesting localized hotspots on the other side. So what a localized hotspot means for our listeners is that the amount of radiation that you have from 20 centimeters away from the router can be the same as 4 or 5 meters away.
Yes.
So that's sort of what happens. Hence, you mentioned that you can have very high radiation at the base of the tower, the way it bounced off the environment. So
what happens is it's wave reflection and then recombination to give you peaks.
Correct. So it's like a snowball effect that keeps bouncing more and more and more. So
it's like waves. You can have gentle waves coming into a harbor, and if they reflect off the wall, you can actually get a super wave right in the middle of the harbor.
And interesting on that super wave, we found the radiation wireless is that it can be 1,000, 2,000 times more than what you expect from the inverse square law.
Yes, that's right. Absolutely. Yes.
So,
anything else?
Well, yeah. So it's what I did, a very simple DIY. I put the shielding on the wall there. And very important, you also have to ground it to an external source, because we have a thing called Maxwell's equation, which means whenever we have an electric field, we're going to have an opposite magnetic field being directed out. So even though it was reflecting the radiation from my neighbor, it was still taking in this electric field. So we had to make sure we dissipated the electric field. Otherwise, there was a magnetic field coming off the entire shielding mechanism that I installed. And this was quite an impact when you have the couch near there and you had your small children, which are a lot more impacted by it, because, just from a SAR model, we know that in the 1 to 4 gigahertz range, the whole body SAR absorption rate for a child, 8 years or younger, is up to 40% more the reference level for an adult that's 2 meters tall. So there's all these other different complications in physics that gets complicated. But again,
open this. I see I faded.
But again, we were joking earlier in the show of how the way I have the strong backlight on me here, so I can have a better balance with the lights, is that I look like one of those people that wants to be anonymous and disclosing information, and probably makes a very airy show of the show. Normally I have a different backdrop and looking at things. And then now with you have this looks like you're the interviewer of me, and you have this bright light and you're turning into this ominous recording. But yeah, so again, it comes down to a multiple of things, but things can be a lot simpler, and that's why we utilize professionals to help give us a better understanding. But 5G, as I said earlier in the previous recordings, a different kettle of fish, and your normal building biologist is not going to understand it, and they have to relearn new things and unlearn what they've learned before of learning quantum biology and how the physics of 5G is different to 0 to 4G.
Yeah. Well, I've got a lot of learning to do, and I've got a lot of paperwork to do. So this weekend, Sunday and Monday, I will be spending long hours. It's all the little things. You have to know how to paginate legal documents. For example, these documents have got to be done with a plastic ring binder on so that they can open up, and I'm going to buy a machine to do that. We've got our own printer that can print out the color, do double-sided and so on. Because to run to PostNet at the last minute, sometimes some of these things I'm working at 12 a.m., 1 a.m. to get them done, to get them into court at 9 a.m.
Yeah. And it's amazing how you mentioned the keyword of pageanting things, because again, we have to also understand that the judges are also being affected by non-native EMF, and their dopamine levels are dropping. So you have to structure the document differently to how it would have been done decades ago. Much more visual, much more bigger, to the point, and giving this relatable narrative or story. Like you said, it's a personal thing to sell.
It's a sales job. I've been in sales.
Yep.
You know, they taught me how to give presentations and talk to people. Yeah. Anyway, it's been really good. What else, as far as the interview is concerned, you've asked me my final words. I gave them. What else should I do?
No, again, the whole point is, you're a super dad here. You've got a lot of information here for a lot of people to reread and listen to and redigest. And we know it's not going to be the last time we have you on the show. We are going to be having you over the months and years. I'm very sure of that, because you're doing a lot of groundbreaking work, and you're helping set a lot of precedents that's going to help other attorneys and advocates, and more important, communities out there and parents themselves following your lead. And
I'm quite happy for advocates and attorneys to take those papers and use them as a template.
I'm very sure they will do, because already it being in court now, it sets a precedent that makes easy referencing, and already the judge's ears are going to pop up. Hold on, this has been done. Like you said, the first judge didn't want to tackle the difficulty that can be encountered by it. But thanks to your reference now, judge, hold on, actually, maybe this is easier for me than I thought it would be. So Clive, thank you so much for being our super dad on the show, and thank you to our listeners for your patience in the series.
Touch informally on email and so on. Thank you. Bye to you, and bye to anybody else who might be watching or listening.
For more, visit www.nicheradio.co.za.